This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. I would like to introduce to you our next story about this man, Timothy Litzenberg, the RoundUp Cancer lawsuit attorney. If you had heard about the RoundUp weed killer, which contains glyphosate, glyphosate has been tied to bad things for people and bees. And this man, Timothy Litzenberg Esquire, says he has represented the plaintiff who won a $289 million verdict against Monsanto, the big chemical company that's always in the news or being criticized by various documentaries and investigations and all that stuff. Big chemical company, easy to sort of get down on the big chemical company, but that's not why I'm here. I am here because Timothy Litzenberg has gotten himself arrested. This is the criminal complaint filed December 16th, just a few days ago, in the Western District of Virginia, and we're going to go over what the heck is going on here. So this is an affidavit in support of a criminal complaint by Kevin Towers, who is a postal inspector employed by the United States Postal Inspection Service. Now, if you read that and at first you go, oh, that's funny, I didn't know that like postal service employees did inspections and stuff. Well, guess what? This guy is basically a detective. And I'm really impressed with the job that he has done on this case. So listen up, this is really interesting. As a postal inspector, employed for over 14 years, he's received training in investigating violations of federal statutes, including conspiracy, wire fraud, money laundering, and other financial crimes. Specifically, he's conducted physical surveillance, electronic surveillance, executed search warrants, analyzed phone and text records, and obtained and reviewed financial documents and records of fraudulent activity. I have spoken to suspects, defendants, witnesses, and other experienced investigators concerning the methods and practices of criminal enterprise groups, especially those involved in financial crimes. So he is legit a detective or investigator. They, of course, would call it a postal inspector. This affidavit is made in support of a criminal charge against Timothy Litzenberg for transmission of interstate communications with intent to extort, conspiracy to commit transmission of said interstate communications with intent to extort, and attempted extortion, as well as conspiracy to commit extortion. Okay, straight to the allegations. According to public records, Timothy Litzenberg is an active member of the bar who lists his employer as the RoundUp Cancer firm. Litzenberg has been involved in litigation against Monsanto, a chemical company that manufactured a weed killer sold under the brand name RoundUp. RoundUp's active ingredients include glyphosate, a chemical allegedly linked to non-Hodgkin's lymphoma, which is a form of cancer. Company 1. We're already getting into the anonymous or redacted companies. Company 1 is a privately owned chemical manufacturer with facilities all over the world. In or about 2018, Company 1 was acquired by Company 2, a publicly traded U.S. corporation listed on the NASDAQ exchange. I am not guessing at this point which company Company 1 is. It could be someone related to Monsanto. I don't know that it is Monsanto, but it's definitely somebody related to the production of glyphosate or Roundup or something. In or about early September 2019, Litzenberg transmitted to Company 1 a draft complaint on behalf of Person 1, whom Litzenberg claimed to represent. The draft complaint alleged that Company 1 and other related companies created several chemical compounds used by Monsanto to create Roundup, some of which the draft complaint alleged to be carcinogenic or cancer-causing. Among other things, the draft complaint alleged that Company 1 knew of the carcinogenic properties of these chemicals, but failed to warn Roundup users and others exposed to Roundup about those risks. After receiving the draft complaint, Company 1 retained outside counsel to communicate with Litzenberg. On or about September 11th, an attorney representing Company 1 spoke with Litzenberg by telephone. According to Attorney 1, on September 11th, Litzenberg described himself as being involved in mass tort litigation. Litzenberg stated that he was working with a Chicago-based attorney, Associate 1, and a Virginia-based attorney, Associate 2, another potential round of RoundUp-related litigation. According to Attorney 1, Litzenberg said that he was considering filing the draft complaint involving Person 1 unless he was granted an in-person meeting with representatives of Company 1. Litzenberg said he would postpone filing the draft complaint for 2 weeks in order to accommodate an in-person meeting. And that's the first place where the hairs on the back of my neck stand up. Okay, that you are making a legal threat with a complaint that you've drafted and that you want something to happen or else you're going to file the complaint. I'm all good there, except he suddenly wants some kind of in-person meeting. Now, this is 2019. Things can be done via email, telephone, conference call, video call. Yeah, lots of stuff can happen. So in-person meetings are things where you might say something off the record. But on a line, on a phone call or on text message or on email is where things could be recorded, right? So just keep that in mind. Following the September 11th telephone call, Litzenberg and Attorney 1 continued to exchange emails and telephone calls about possible further meetings. During the course of communications, Litzenberg pressed for an in-person meeting in Charlottesville, Virginia. In an email to Attorney 1 on October 15th, which is obviously like more than 2 weeks later, right? Litzenberg wrote that he had no intention of holding the draft complaint until November. However, as one more gesture of good faith, I would be willing to hold off a couple weeks under the following terms, which included scheduling a meeting on Halloween in Charlottesville, where I generally conduct most significant and discreet business. On October 16th, he had another telephone call with Associate 1 and Attorney, or Associate 2 and Attorney 1. During the telephone call, Attorney 1 was outside the Commonwealth of Virginia. According to Attorney 1, Litzenberg stated during the call that he still intended to file the draft complaint unless a resolution was found. Litzenberg indicated that if he did file a public lawsuit, other lawsuits would likely follow as the public became aware of Company 1's role. According to Attorney 1, Litzenberg and Associate 2 indicated that they represented 800 clients in RoundUp-related litigation against Monsanto. Litzenberg indicated that to date he has not informed any Monsanto client about Company 1 or the possibility of bringing a RoundUp-related lawsuit against Company 1. First major problem. When you are an attorney and you represent somebody, you have a fiduciary duty to them, which means you must recommend things that are in their best interest, or you better be terminating your relationship with them. While you are representing them, you cannot be acting in your own best interest if it is to the detriment of your client. It always has to be in the client's best interest. That doesn't mean you can't charge them money. It doesn't mean that you don't have a business relationship and all that, but it means that there are rules and you must follow the rules. And here he is starting to break those rules in a very distinct way. According to Attorney 1, after describing the possibility of the lawsuits against Company 1, Litzenberg proposed that he and Associate 2 could enter into a consulting arrangement with Company 1. Doing so, Litzenberg stated, would create a conflict of interest that would effectively stop him from representing plaintiffs in litigation against Company 1. This is major problem number 2. You cannot represent clients who have a concurrent conflict of interest, except under very specific circumstances where both parties are fully informed, have made sort of a statement in writing that they understand the concurrent conflict of interest and they're still willing to work together with the same attorney. And even then, if the concurrent conflict of interest is too great, judges and bars will not allow you to do that. And you can get in a lot of trouble for it. Here, he is not accidentally representing two willing parties who have a concurrent conflict of interest. He is purposefully trying to create a conflict of interest for some reason that we're maybe about to find out. On or about October 18th, Litzenberg and Attorney 1 had another telephone call in which Litzenberg again raised the issue of entering a consulting agreement with Company 1. According to Attorney 1, Litzenberg stated that as a first step, he wished to settle the case between Person 1 and Company 1 for $5 million. Okay, I mean, if that's what person one wants to settle for, great. But if he's doing that for his own reasons, that's not allowed. According to Attorney 1, separate from the $5 million settlement for Person 1, Litzenberg indicated that he separately wanted consulting arrangements for himself and Associate 1 worth a total of $200 million. Wow. Litzenberg described the $200 million as the bottom line. According to Attorney 1, Litzenberg also indicated that instead of the consulting agreement with Company 1, he would also accept a consulting agreement with Company 2, of which Company 1 was a subsidiary. Maybe Company 2 is Monsanto? I'm not sure. According to Attorney 1, Litzenberg also clarified that the $200 million would not be used to resolve any of the potential lawsuits that could be brought by the other 799 clients. Litzenberg stated that the $200 million in consulting fees would not result in additional releases from litigation by those plaintiffs. So then October 24th, Litzenberg emails Attorney 1, quote, "Please accept this email as a written demand in follow-up to our discussion about the same." In the email, Litzenberg reiterated his demand for a $5 million settlement for Person 1 and a $200 million consulting agreement for himself and his associates. Was he unhappy with whatever cut he got from the $289 million that he already won? Or maybe they haven't paid up or something, so he hasn't gotten that, but he feels especially feisty or something? This is the stupidest thing I've ever heard of, except for the Christopher G. Hook situation. Litzenberg described resolving Person 1's case as only a first step. Litzenberg said, if Person 1's case is resolved, we would simply advertise and sign up more users of RoundUp home products that contain Company 1 chemicals. In fact, that is precisely our plan, absent some agreement to the contrary. Litzenberg continued, the Company 1 non-Hodgkin's lymphoma litigation that we are planning will be RoundUp 2. And I'm excited to lead the charge again, this time to my great financial benefit. What? Let's see what this footnote says. Litzenberg claimed in his email to have been instrumental in the prior RoundUp litigation, stating in part, I filed the first RoundUp case against Monsanto, retained the first experts, took the first depositions, and likewise maneuvered the case to trial and a $289.2 million verdict for my client. But somehow he was not satisfied with his pay. Litzenberg stated that if he filed suit against Company 1, there would quickly be a docket of thousands of cases. If litigation commence, he warned, this becomes, an ongoing and exponentially growing problem for Company 1, particularly when the media inevitably takes notice. The defense costs and cost to ultimately resolve the thousands or tens of thousands of cases would be well into the billions, setting aside the associated drop in stock price and reputation damage. Instead of the supposed consequences of litigation, Litzenberg suggested a potential solution that would avoid the cost associated with litigation, reputational damage, and a drop in stock price. Specifically, Litzenberg proposed that Company 1 and Litzenberg enter into a consulting arrangement with Company 1 or a related entity or some other relationship, that's his typing apparently, that would prevent my firm from suing Company 1. Litzenberg claimed that with such a consulting arrangement, Company 1 would weather the storm and avoid the parade of horribles I outlined in short form above. Litzenberg continued, our demand proposal related to a consulting agreement with my firm and Associate 1 is $200 million to be shared by our firms. As I previously mentioned, please do not misconstrue this demand as an indication that we would accept half of that or less. Litzenberg later described the $200 million demand as a very reasonable price compared to the significant financial consequences to Company 1 of a protracted and public RoundUp 2. Litzenberg concluded by reiterating his request for an in-person meeting on Halloween in Charlottesville, Virginia, stating, I hope Company 1's board and any other decision makers have a chance to consider these demands proposals. Just to set expectations, this is something we would like to resolve in 2019. Wow. Okay. On or about October 29th, Company 1's outside counsel contacted prosecutors from the U.S. Department of Justice regarding Litzenberg's actions. On or about October 30th, DOJ prosecutors and I, the postal inspector, spoke telephonically with Company 1's outside counsel. During that call, Attorney 1 summarized her prior contacts with Litzenberg. Attorney 1 also reported that she and another attorney, Attorney 2, expected to speak telephonically with Litzenberg on or about October 30th. Attorney 1 and Attorney 2 agreed to allow U.S. Postal Inspection Services to record this telephone call. On or about October 30th, 2019, Attorney 1 and 2 spoke telephonically with Litzenberg, who they understood was in Charlottesville at the time. During the call, Attorney 2 asked how Litzenberg arrived at the $200 million figure he asked for in the consulting fees. Litzenberg responded, "It's opportunity loss," later adding, "I think it's lower than the extraordinarily low end estimate of what Associate 1 and I would make off this litigation." He added, quote, "The way that I guess you guys will think about it is we've thought about it too, is savings for your side. I don't think if this gets filed and turns into mass tort, even if you guys win cases and drive value down, I don't think there's any way you get out of it for less than $1 billion. And so, to me, this is a fire sale price that you guys should consider, for a limited time." Attorney 2 then asked about where the $200 million from Company 1 would be sent, asking, "The money is not going into an individual plaintiff's compensation fund or anything like that. This is money that is going straight to you and your partners, correct?" Litzenberg responded, quote, "It is our analysis, retainer, Virginia law, and actually American bar sort of standard law that we have no obligation at this time to recommend to our clients to add Company 1 into a suit because manufacturers I've laid out for you before. That doesn't mean we're prohibited from doing it, but we think very strongly that we have no obligation to do so whatsoever." He also said, "We have to carefully research everything, but we have already been doing so with some of the top ethics lawyers and big firms already, asking some general questions about this." Litzenberg never identified these purported ethics lawyers or their analysis to Company 1 or the lawyers representing them. Attorney 1 asked how the consulting arrangement with Company 1 would prevent lawsuits from getting filed. Litzenberg responded in part, "I think we can talk to people we knew. If they were thinking of going that route, thinking about suing Company 1, I think Associate 1 is going to be a real asset there. Anybody thinking of filing a mass tort lawsuit in Chicago is going to come to Associate 1. And if he says, 'Well, we thought about that. We thought it was a terrible idea. You should move on.'" Litzenberg clarified, "Of course, I've explained to you guys what I think I win with juries is on causation, but nobody else is going to figure that stuff out. I think that the likelihood people come to me or Associate 1 first before going down that road is pretty high." Later in the telephone call, Litzenberg said to Attorney 2, "You could forward your own toxicology experts or something at a pre-trial deposition. I mean, a pre-suit deposition as part of some sort of, negotiation with a pre-suit. And we ask the wrong questions." What? Wait, and we ask the wrong questions. So he's saying he's going to intentionally ask the wrong questions so that the cases can't be advanced.
That is something else.
Oh, but wait. It keeps going.
Oh, dear.
Litzenberg explained that as a result, you would have a deposition transcript where I basically got whacked, but did nothing. And that could sort of be something that you kept in a vault somewhere to pull out if you ever got bothered by someone that didn't know me or whatever. Litzenberg later described this tactic as one where he would almost sort of take a dive, as long as it's legal, ethical, and the best one for our client, of course.
You mean
what?
Are those options?
No, you don't know. Oh my God. I mean, yeah, that's just no.
I mean, none of those options are best for your client, so
I don't understand how you could say this with a straight face. Man, this is right up there with the Christopher Hook stuff. Like, just putting this crap in, like, doing this in the first place is horrible, and then you put it in writing just nails your coffin shut. I mean, you don't even have it. He doesn't have any defense at this point, I don't think. And this is my opinion. I'm not trying to like defame the guy. These are allegations, but holy crap. If these allegations are true, this is the stupidest thing I've ever heard anybody do besides the Christopher Oak thing.
Maybe it's a Leibowitz defense, it's just, my client was so bizarre at the time, if someone's competent, how could they possibly...
My client couldn't have been in the right state of mind because no one in the right state of mind would have done this.
Amazing.
The crime my client is committing is so insane that my client must have been insane to do it.
It's made up, right? This is not actually a thing that happened, right?
During his communications with Company 1, Litzenberg repeated variations of the phrase legal and ethical dozens of times. Litzenberg never elaborated on that statement beyond repeating it frequently, nor has ever identified an action he would not take due to legal or ethical considerations. At another point of the conversation, Litzenberg suggested that as part of the deposition exercise in which he would take a dive, Company 1 and Person 1 could purport to execute a high-low agreement, with the minimum amount set to the actual amount demanded by Litzenberg. Litzenberg explained that they would settle for the minimum in the purported high-low agreement after the deposition, making it appear that Person 1's lawsuit had not been successful at the deposition stage of the proceeding. You guys remember Prenda Law? They tried something like this, and it worked too. Of course, they got caught and thrown in jail, but what they did was they got a defendant, like the number one defendant of many. They got the first defendant to agree that if the first defendant takes a dive, then they won't prosecute that person behind the scenes. But publicly, they would come after that person hard, and that person would then fold and agree to allow the subpoena of thousands of other defendants. And by doing that, the company Prenda Law actually did succeed in acquiring thousands of people's identities, and then they were able to send demand letters to thousands of people who they claimed were all copyright infringers, when indeed it was all a sham. This is very much like that. This part of Litzenberg's thing is very much like that. Person 1 is going to take a dive, and then that's going to be used as an example to prevent the other, 800 clients, plus anybody else out there who's got cancer from Roundup and glyphosate, allegedly. Those people won't have any claims anymore. He wants to take the rights away from people who have cancer. Great guy. Great guy. During the recorded telephone call, Litzenberg repeatedly said that he represented hundreds of clients in pending Roundup-related litigation against Monsanto. Litzenberg also stated that he would continue representing them in the Monsanto litigation. At one point, Attorney 1 asked what would prevent the clients from switching firms and bringing up another claim. Litzenberg responded, "Well, I have no idea what would prompt that, I guess is my first question. I have no idea what would cause that. None of them have ever heard of Company 1, and none of them have ever heard of name of company affiliated with Company 1. Because I'm assuming it's like a doing business as or something. Again, our analysis is that with a settlement right around the corner, some of them will be waiting for years. We're not going to suggest that they wait another 5 years to get a Chicago trial date when they have probably a bird in the hand right around the corner. Whatever this means. Talking about other clients he purported to represent in Roundup litigation against Monsanto, Litzenberg stated that he was absolutely not obligated to recommend to clients the possible litigation against Company 1. Yes, he was. Yes, he was absolutely obligated to recommend to his clients that they litigate against the company that purportedly caused their injuries. Yes, he has. Not an unhired attorney. This is someone who claims to have been hired to represent those people. He then has that duty to tell them. If that's all true, he had that duty. Litzenberg claimed that our retainer agreement gives us the full discretion to decide what entities are most worth going after for you to get the most in the least amount of time, essentially. If you ever hire an attorney, you can't agree away their professional responsibilities. There are some things like a concurrent conflict of interest, but that's built into the rules. You can't sign, an attorney can't enforce an agreement that has you signing away the attorney's responsibilities to the client. The most that I've ever heard of the actual ability to sign away responsibilities are things like limited scope representation, where as long as I make it clear that I'm only representing you for a limited purpose, then you can do that. This is not that. He is saying here that the retainer agreement gives him the discretion to decide what entities are sued, even if that goes against his fiduciary duties to the client. And that's not true. You cannot sign that away. You always owe a fiduciary duty to the client. The limited scope representation I'm talking about is more like where, I'll give you my example. I represent people in negotiations, for example. So I'll charge somebody a smaller amount of money to represent in a limited circumstance like just negotiations. So I have to be very clear. It's on me to be very, very clear in my agreement that I am only representing the client in a very specific circumstance, and that here are the other circumstances that I'm not representing them, or here's what happens if those circumstances are triggered or something like that. He's not doing any of that. He's just selling out his clients so that he himself can make some part of the $200 million. Litzenberg implied that he could therefore steer away those existing clients from Company 1 if the parties reached a consulting agreement. No. On or about November 6th, Litzenberg continued to seek the consulting agreement via email. He began by claiming to have a list of 1,000-ish RoundUp clients who hired me to sue Monsanto, and the number is growing every day. However, he said that person 1 is the only client with whom we have had discussions about a claim against Company 1. However, Litzenberg said that without a consulting agreement, he predicted that he would have thousands of future plaintiffs, which he could find through our extensive network of referral lawyers, lead generators, and advertising machinery that you know well could produce thousands of new claims and clients for me by the new year. He continued, while I cannot guarantee and warrant complete finality, Company 1 will be exceedingly well positioned to weather this storm if it settles my single case and if we subsequently agree to offer consulting. Entering a consulting agreement, Litzenberg claimed, will mean that Company 1 avoids the parade of horribles that has been the RoundUp litigation for Bayer Monsanto. Litzenberg concluded, this is another thing I can guarantee and warrant in the absence of a so-called global or final deal with me. This will certainly balloon into an existential threat to Company 1, meaning he's going to sue Company 1 into the ground unless they agree to his demands. He repeatedly requested an in-person meeting and made the following introductory comments at the beginning of the meeting. I assume that a company as smart as these companies has had reserves in this, whether you guys were involved or something from the, it's been a concern, I'm sure. You don't have to try to convince me otherwise. And I'm sure if they have been watching the litigation, those reserves are multiples of what we're talking about here. And they've been biting their nails for years over this, waiting to see, if this problem is going to come to a head. And we have brought the problem to a head, but only among the people in this room. And so now there is a problem to solve that I think brings certainty. All I'm certain of is we're going to be the leading edge of the next mass torts. I took a hard left at pharmaceuticals. I may take a hard left at chemicals and pesticides. We'll see. That remains to be seen and decided largely by, your client. But I'm sure that we'll be leading that and both formally and informally. What's certain is that if we walk out of here today without a deal and we, person 1, case gets filed and gets served, and we're talking about the consequences. Early on in the meeting, Litzenberg stated that if litigation commenced, there was no way Company 1 gets out of it for less than $1 billion. We can be your biggest problem, he said. Right now, we're your only problem or potential problem. We have one identified certain conflict that we can discuss, and we can discuss some other creative ideas. We can be an asset, and I've talked about creative ways to not only make the problem go away, but try to help Company 1 and perhaps its sister companies avoid this problem and other problems in the future. Later on, Litzenberg again stated the litigation he contemplated would have adverse effects on the stock price. We absolutely making $250,000, $500,000, $1 billion+ investment in a public relations nightmare. In a 40% stock loss coming off the top. And that's what they're deciding between, is whether to avoid that or to buckle down for that. There is no, I know you're going to have a call to tell your client. The client is going to be understanding, probably, because they're going to be saying, we don't have to deal with this. They've got a way bigger than $250,000 investment in a nightmare. Wow. Let's see. So Company 1 inquired about the deposition that Litzenberg proposed doing, the one where he was going to take a dive, and he responds, I mean, it depends on what you're asking for. But yeah, something prevents exposure for y'all and erase the trail like we've talked about. It borders into misrepresentation and taking a dive sort of thing. Oh my God, he actually said it out. He actually said it out loud.
If you have to say the words and erase the trail, you should stop and think real hard about your life decisions.
Yeah, I mean, so what is I'm reading this book, The Cuckoo's Egg. It's a great story about how a scientist found a hacker in the more or less early ARPANET, and it's really great. And one of the things that hacker did was clean up their trails, as they would log into a computer illicitly, and then first thing they would do is find all the logs of them logging in and erase them. And this guy is not that smart. just didn't even think about that.
This is all on the record, so he's admitting to all. I mean, I guess the best defense he has.
I mean, he might not have known this was on the record. I mean, at this point, this is being recorded because the attorneys had ethics. The other attorneys had ethics.
What's his defense? I mean, I guess it's that, I was trying to egg them on and reveal their ethics issues.
Yeah, it's going to be the Christopher Hook defense. I was just being aggressive, Your Honor.
Yeah. Whew.
Wow. He says, I think it's okay as far we've looked at, but for reasons that it would be something for us and reasons I'm sure you can figure out to do on a first case before we can't do it under a consultancy with you before we settle the case. I don't think that it's either in either of our best interests, but I tossed it out there. If there is some way that you guys can ensure that, it happens legally and ethically, then there is surety on our part that's followed by this consultancy. Wow. At another point, Litzenberg was asked who would be deposed. Litzenberg responded, I was suggesting your toxicologist. I think it would be better than trying to set up something where, like, our toxicologist takes a dive. So their toxicologist had to be involved. Maybe not take a dive. I think it was Litzenberg is going to take the dive in the deposition with their toxicologist. I think that's what it's saying here. During the meeting, attorneys representing Company 1 asked what entity would serve as the entity to which the $200 million would be paid. In Litzenberg's presence, Associate 2 stated the money would be paid to Golden Ratio LLC and confirmed that Associate 2 and Litzenberg were the beneficial owners of Golden Ratio, which is a Virginia entity. I don't know what Golden Ratio stands for. Does anyone know what a Golden Ratio is? Is it like a play on something? I don't know.
No, it's E. It's the ratio between.
Oh, it's mathematics. It's mathematical E.
Yes.
Oh, okay, cool.
Yes.
Oh, the Golden Ratio is like 3/2 or something, right?
It's something.
Like 2/3, I think, is the Golden Ratio.
It's close to 1.5. Yes.
During the in-person meeting, Litzenberg was asked what would prevent his current client from telling other people about the settlement with Company 1 were it to happen. Litzenberg clarified that Person 1 had not seen the draft complaint sent to Company 1 in her name. Person 1 had not seen the complaint sent in her name and did not believe they had ever mentioned the name of Company 1 to Person 1. This is a person who has cancer. This is a person who hired an attorney to represent them in helping get the proper recovery for their suffering. And Litzenberg is taking advantage of them. And now it's not one person, it's 1,000 people. This is a scumbag. This guy is an absolute scumbag, if this is true. On or about November 14th, Litzenberg sent Attorney 1, Attorney 2 an email. The subject consult looked for 2 consulting arrangements, one for himself and one for Associate 2, and a separate agreement for Associate 1. Okay, we're getting into details that aren't that terribly interesting.
But there was actually an agreement. So it's not like he was just talking this up. There was an actual agreement that was even sent around.
Yep.
So the execution of this had begun at this point. And this is where the defense of, oh, I was just trying to talk it up goes completely away.
Now, I'm guessing that attorney 1 and 2 are in on it with the DOJ at this point. So they're not really too worried about their own ethics complaints.
Yeah.
And by the way, okay, so how did that happen? When do attorneys have to report? Well, we found out during the Alex Maurer thing that attorneys have to report when there is a threat of physical bodily injury or death. Usually it has to be severe. It can vary a little bit from place to place, but I'm talking about more or less the ABA model rules of professional conduct here. And there's a second duty to report if your client says that they're going to commit an act of great financial disaster or whatever. They're going to steal a bunch of money or something. Not a client's coming to you and says they already stole a bunch of money, but rather they say, oh, I'm about to. Then you usually have a duty to report. So you have to contact authorities and say, I got this client and he just told me he's going to steal money from this company. I have a duty to report. And so you have to, complete whatever reporting process that the police and authorities want. So in this case, they contacted the DOJ and agreed to work with the DOJ. Or, maybe the DOJ got wind of it somehow and then contacted them. I don't really know. I think it said they contacted the DOJ. But I'm concerned about Litzenberg. I'm not too worried about Attorney 1 and 2 right now. In fact, if Attorney 1 and Attorney 2 or whoever did affirmatively contact the DOJ and all that, good. Thank you so much for saving some face of our profession, because Christopher Hook and Timothy Litzenberg are doing their absolute best to destroy it. Their absolute non-level-headed best, right? As discussed above, Litzenberg at one point proposed that he could assist Company 1 by taking a dive during a deposition of a toxicology expert in order to undermine the merits of any subsequent litigation of Company 1. In furtherance of the supposed dive, Litzenberg's second email included written requests that he would expect to be the substance of probably 2-hour bellwether toxicology depositions to be such as we discussed, would then include approximately 37 topics and questions dealing with toxicological subjects and connected to the carcinogenic effects, etc. And they then had a phone call November 15th with more demands for the consulting arrangement. He stated that of the $200 million in consulting fees, $50 million would go to Associate 1's entity, and the remaining $150 million would go to Golden Ratio. So some portion of the $150 million would then be Litzenberg's. He stated, if I have a problem in the future that I need to get taken care of, I will refer to Associate 1, a single products liabilities case. He will understand that that is sort of a wink to go to the manufacturer of the product and do a private one-off settlement. Wow.
I'm speechless.
Yeah, this is whew. Okay, here's the hard and fast of it. Litzenberg identified a client list of clients, which was approximately 1,001 entries, each purporting to have the initials of the litigant, the date they were engaged by Litzenberg, and plaintiff's purported state of residence and zip code. So these sound like these are real people. I mean, at this point, I kind of hope he's making up the 900 or the 1,000 plaintiffs, because if he really has collected 1,000 plaintiffs and then tried to extort based on, he has done a tremendous disservice to them. Some of those people might have claims that are expiring off a statute of limitations, and he's messing with that. And there is no way that Timothy Litzenberg has the money to cover all of those claims himself. So there's some point at which these cancer patients are not going to be able to recover from the chemical company, and they will not be able to recover from Litzenberg. Some portion maybe, but it's going to be like a class action lawsuit where everybody gets $3, right? Litzenberg identified the second attachment as the substance of the Associate 1 agreement. It was a confidential agreement in which the parties agree that as of the date of execution, the Company 1 will retain Associate 1 as an ad hoc consultant. It provided, this agreement is of strict confidentiality. Its existence, nature, content, or details shall not be disclosed to third parties, absent express written agreement or a valid court order. Well, sounds like they had a warrant, huh? As to the length of service, the document said that it shall consist of 99 years. Finally, it provides for a $50 million payment on January 2nd. So he concludes, based on my training and experience and the information provided in this affidavit, I respectfully submit that there is probable cause to believe that beginning on the date unknown, Timothy Litzenberg committed transmission of interstate communications with intent to extort and conspired to commit transmission of interstate communications with intent to extort and attempted extortion, as well as conspiracy to commit extortion. And that is Postal Inspector Kevin Towers. Holy mackerel, that is great work. Wow. And this is sworn before the Honorable Joel C. Hoppe, United States Magistrate Judge. And then, I'm not sure if you're aware, he got arrested. Roundup suit lawyer accused of $200 million extortion plot. Lawyer for Roundup plaintiffs charged with extortion. Attorney for Roundup Cancer Plaintiffs arrested on criminal charges. Lawyer who fought Monsanto arrested on extortion charges. Virginia attorney charged in extortion plot over Roundup. Like, you saw me laughing at this at first, but then it sort of hit me. And there's nothing wrong with laughing at this guy's Schadenfreude, but then I remembered that there were 1,001 basically cancer patients, right? You wouldn't necessarily be coming to a Timothy Litzenberg if you had no symptoms, if you were fine, right? I mean, obviously there are some people who are going to come to an attorney, especially having, like, imagine you worked with Roundup as a pesticide your whole life or something, or as long as it's been around, because it's been around for a while. And you know that you've been in contact with it. Well, maybe you want to get the things rolling with your attorney, but come on, most people are going to be experiencing some kind of symptoms or experiencing some kind of trouble or something, and they then come to the attorney for the claims. And he takes advantage of cancer patients. I mean, that's just unforgivable.
Yeah.
What do you think, Joe? How many lifetimes do you think this person should be in jail if this stuff is all true?
I mean, life.
5, 10.
The 1,001 is true.
Yeah.
I think oh my God,
yeah,
that is serious.
At this point, I'm really hoping that is a made up list. I am really hoping that is a made up list.
I could see it. I mean, why?
Wow.
Honestly, why bring it up if it's not at least a little bit of truth to that?
Yeah. Wow. I mean, and he apparently had 1,001 entries in an Excel spreadsheet or PDF or something with names and zip codes and something or other. So I hope that the DOJ and these attorneys who had the ethics to come forward and turn Timothy Litzenberg in, I hope that they are able to represent these people and accomplish something for them. I don't mean that we automatically know that they will win every lawsuit. It's probably not the case, but it's the claims that are now in question in all. Like, in other words, these people now, they're going to bring this claim, and this is going to always be in between them and their claim. Do they have a proper claim, or was Timothy Litzenberg just leading them on? And are they going to spend thousands and thousands of dollars on attorneys to find out whether Timothy Litzenberg was leading them on or not? This is a horrific situation. I almost feel like there has to be a victims fund set up just to help get these people to the correct attorneys and get them into their trial. And then the person who should have to pay for that victims fund should be Timothy Litzenberg.
Because he does have some money, because he did do all the lawsuits.
Yeah, he did win some portion of that $289 million, I'm sure. Unless he was like hourly for that, which, I mean, it could happen, but that would be a unfortunate situation.
It would seem a little out of character with the way that he's...
Whew. Don't be like Timothy Litzenberg. Genuinely represent your clients. Do not bring shame upon the profession like Timothy Litzenberg allegedly has done. So thank you for joining me. That's our show. I hope you enjoyed. I am Leonard French, your favorite copyright attorney. This is Lawful Masses, your favorite legal news and education and story channel. We are always trying to find you stories to tell you about the law and help you learn something along the way. We are supported financially by patreon.com/ljfrench supporters and sponsors.com/law supporters. At the $50 level in the month of December, we are very thankful to have the following supporters helping out our channel: Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Rumble in the Bunghole, and Cute Grills in your area. And thank you to the rest of our $5 plus supporters. You'll be scrolling in front of me when we release these as videos on YouTube. Thank you for joining me. I'm Leonard French, your favorite copyright attorney. I hope you have a wonderful Yule celebration, solstice celebration, Festivus, and of course, Christmas, Hanukkah, Kwanzaa, and holidays. I love you all. I will see you in the videos that drop